Good afternoon, ladies and gentlemen. My name is Robert Khuzami. I'm the Deputy United States Attorney for the Southern District of New York and the Attorney for the United States in this matter. With me is Bill Sweeney, Assistant Director in charge of the New York Field Office of the FBI, and James Robnett, who is the Supervisory Agent in charge of the New York Office of the IRS. Also with me are the prosecutors from the United States Attorney's Office in the Southern District of New York who prosecuted the Cohen matter. I'm going to have a brief statement and will not be taking any questions. Today, as you heard, Michael Cohen pled guilty to 8 felony charges. 5 of those dealt with tax evasion for the years 2012 through 2016, in which he failed to report approximately $4.1 million in reported income. Approximately 2.5 of that money was from interest payments from a personal loan that he failed to report. Approximately $1.3 million of that money was from the operation of his taxi medallion business. Approximately $100,000 of that money was from brokerage commissions, and over $200,000 was from consulting fees. That's over $4.3 million over a 5-year period, which translates into a loss to the United States Treasury of approximately $1.3 million. In addition, in count 6, Mr. Cohen pled guilty to making false statements to a financial institution in connection with an application for a home equity line of credit. In that application, he failed to disclose more than $14 million in debt that he had, and as a result of that concealment, he obtained that $500,000 line of credit, which he would not have been entitled to had he been candid and honest. In addition, Mr. Cohen pled guilty to 2 campaign finance charges, one for causing an unlawful corporate contribution, and a second one for personally making an excessive personal contribution, both for the purpose of influencing the 2016 election. In addition, what he did was he worked to pay money to silence 2 women who had information that he believed would be detrimental to the 2016 campaign and to the candidate and the campaign. In addition, Mr. Cohen sought reimbursement for that money by submitting invoices to the candidate's company, which were untrue and false. They indicated that the reimbursement was for services rendered for the year 2017, when in fact those invoices were a sham. He provided no legal services for the year 2017, and it was simply a means to obtain reimbursement for the unlawful campaign contribution. A couple of points I'd like to make. First, these are very serious charges and reflect a pattern of lies and dishonesty over an extended period of time. They are significant in their own rights. They are particularly significant when done by a lawyer who, through training and tradition, understands what it means to be a lawyer, to engage in honest and fair dealing and adherence to the law. Mr. Cohen disregarded that training, disregarded that tradition, and decided that he was above the law, and for that he was going to pay a very, very serious price. With respect to the campaign finance violations, the campaign finance laws are designed to prevent the use of illegal money in elections and to maintain the integrity of those elections. Mr. Cohen made guilty pleas for those campaign violations, and those are core violations. And what he did was, these pleas remind us that it is illegal for corporations to make contributions to candidates, and it is illegal to make contributions in excess of the amount that Congress set for individuals. That is a strong message today, and we will not be, we will not fear of prosecuting additional campaign finance cases. Lastly, and perhaps most importantly, this case is unique in many ways. Just witness the gathering of all of you here today. And in other ways, it's unique as well. But in the really important ways, this case is not unlike many cases that my office, the United States Attorney's Office, brings, that the entire Department of Justice brings, and that the law enforcement agencies do as well, including the FBI and the IRS. This case has more in common with all those cases because they all share the same message. And that message is that the rule of law applies, and that for law enforcement, all of whom are gathered here, it is our commitment that we will pursue and vindicate those who choose to break the law, and vindicate the majority of people who live law-abiding lives, who follow honest and fair dealing, and live lives of lawful behavior. The message is that we are here, prosecutors are here, law enforcement is here, the Department of Justice is here, the law enforcement agencies here. We are a nation of laws, and the essence of this case is justice, and that is an equal playing field for all persons in the eyes of the law, and that is a lesson that Mr. Cohen learned today, and it is a very harsh one for him. Thank you very much.
Who is the candidate you're talking about?
Oh, I'm sorry. One other thing. I'm sorry. I'd also like to introduce. Sorry, my fault. I really want to thank Mr. Sweeney and James Robnett of the FBI and the IRS and the agents who work for them. We do many cases with them, and their determination and their fair dealing and their vigor with which they pursue their cases is really inspirational. To the prosecutors in my office, I cannot express the gratitude for the hard work that they did in this case, and that is Assistant United States Attorneys Andrea Griswold and Nick Roos and Rachel Maiman and Tom McKay, as well as Ed Discant, the Deputy Chief of the Public Corruption Unit, and Russell Capone, the Chief of the Public Corruption Unit. For all of these people, I could go on and on about their many virtues and talents, but the one important thing is they all are satisfied with simply being known as public servants, prosecutors, and law enforcement agents who are doing their job. Thank you very much.
Can you tell us who the candidate